Okay, good morning, good afternoon, good evening to everyone as they join us. I know people will continue to trickle in, but I wanted to get started. Hopefully everyone can see my screen. I got a new computer over the weekend, which is like causing me a lot of heartburn right now to make sure everything is going okay as planned. This is our annual year in review international family law update. I'm joined by James Netto from the International Family Law Group in London. This is an hour-and-a-half presentation. We fill pretty much the entire hour and a half. So you may post questions in the Q&A and chat. We may not get to them or we may not see them before the end of the program. Everyone here who has registered will be getting an email as a follow-up with the recording and with our PowerPoints. So no need to ask if we can send you the PowerPoints. They will get to you with all the names of the cases and the updates that we're going through. So I'm going to get started because we have a really full agenda. I'll go for about the first half of the 1.5 hours, and then I'll give it over to James, who always has much more interesting things to share than I do. They are crazy over there, I tell you, in their cases, even more so than we are. So let's get started, and I'm going to give you just this overview. In addition to what you'll get in the webinar as the follow-up email, all of my cases are also on this website that I put together, Family Law Across Borders. So make note of that. You can see all the case summaries there and all the links to the cases. So the first update, the Hague Conference on Private International Law's governing body, its Council on General Affairs and Policy, met in March of 2021. I mean, that seems a long time ago now. It does that every year, every March, so we'll be meeting again soon. During that meeting, it discussed several upcoming special commission meetings. The genuine hope is that the delayed child support special commission for the Child Support Convention will be held in person or in a hybrid model this year, fingers crossed. The hope also exists for the Adoption Convention Special Commission, these routine every about 5-year meetings to discuss the treaties. And at present, the Abduction and Child Protection Convention's 8th Special Commission will be held in late 2023. Tentatively, there are several topics that are already on the agenda for discussion: the interpretation of habitual residence, further discussions on the Article 13b Guide to Good Practice, hearing a child's voice, good practices to reduce delays in proceedings, remote proceedings by video link, the interaction between treaties and things like the Hague Abduction Convention and the Refugee Convention, for example, non-Hague conventions, and practices in international family relocation. On October 19th, the Hague Child Protection Convention had its 25th anniversary. It was celebrated by a virtual event hosted by the Hague Conference, and all of the videos can be found on their YouTube channel as well as their website, hcch.net. And finally, James and I would like to congratulate Dr. Geraldine Go-Escalar. She ably served as first secretary responsible for several of the family law conventions. And on January 1st this year, a mere 18 days ago, she was promoted to Deputy Secretary General of the Hague Conference. So congratulations to Jerry. Okay, so now the US Department of State, they issue a yearly compliance report as mandated by Congress. It visits outstanding child abduction cases from the United States to other countries and explores some of the underlying reasons why these cases are still unresolved. The report includes both countries where there is a treaty relationship between the US and the other country under the Hague Abduction Convention, and countries where there is no treaty relationship and perhaps no laws in place that dictate return of children that are abducted. The report looks at statistics for the year prior to it being issued. It lists countries that are not compliant. Non-compliance is actually defined under the International Child Abduction Prevention and Return Act, ICAPRA. And that is the federal law that actually mandates this report. The 2021 non-compliant countries were Argentina, Brazil, Costa Rica, Ecuador, Egypt, India, Jordan, Peru, Romania, Trinidad and Tobago, and the UAE. The only, on this list of non-compliant countries, it It was exactly the same as the 2020 list, except that Trinidad and Tobago was added to this particular list. No countries were removed from the 2020 list, and the next list should be out proximate to April or May of this calendar year. On June 11th of 2021, the United States declared its acceptance of the Seychelles to the Hague Child Abduction Convention. The treaty entered into force between the US and the Seychelles on September 1st of last year. The Seychelles did not appear in the 2021 US Department of State Compliance Report, meaning that there was no reported cases of a child being abducted from the United States to the Seychelles. And it also did not appear in the 2020 or 2019 reports. On December 3rd, the Hague Evidence Convention entered into force between the US and Georgia and the US and Vietnam. And then that allows us to move on to some of the case law that's going forward. So most of the international family law updates in the United States are cases that are brought under the Hague Child Abduction Convention, often in federal courts. So one of the fundamental things a petitioner must prove in a Hague abduction case is that the child was removed from or retained outside of that child's habitual residence. The 2020 US Supreme Court case of Manaski versus Talieri provided for a totality of the circumstances test for judges trying to make that assessment in their cases. After a rocky start applying this new test, most courts have started to find their groove in 2021, and with the standard on appeal of only overturning a trial judge's habitual residence finding if there is clear error, the trial judges now have significant discretion in the United States to view the facts as they see appropriate. In early 2021, in Minkowitz versus Becker, the Court of Appeal of California affirmed the return of a minor child to Mexico under the Hague Abduction Convention. It concluded that Mexico was the child's habitual residence. In this particular case is a little interesting. The two parents and the child, all US citizens, lived on a boat. They lived on a boat that went from Marina del Rey, California, and in late 2016 set sail for Mexico. By early 2017, they had moored their boat in Mexico, enrolled their son in school there, and acquired permits and visas to reside in Mexico. They did, however, still drive back to Los Angeles for medical care and maintain car insurance and bank accounts in the United States, even though the trial judge reached their decision prior to the Manaski ruling. The judge examined all of the facts and concluded that the family's continuing ties to the US were more akin to that of an expatriate family, and not that they had intended to remain in the United States as the habitual residents. In late 2020, in the case of Dumatrascu versus Dumatrascu, this is where London has it right. You use acronyms, like A versus B. I have to actually pronounce all these names. The US District Court for the District of Colorado ordered the party's minor child returned to Romania under the Hague Abduction Convention. It concluded that Romania, which is where the child was born to a Romanian mother and an American father, was the child's habitual residence. The parents who had been living in Colorado chose to go to Romania to have the child because of the free medical care that they would receive. And then they decided to stay in Romania for 10 months after the child's birth before the father decided he was going to travel to the US with the child to get the child her US Social Security card and reapply for the mother's US green card. For the child to exit Romania with only one parent, the parents had signed an affidavit that permitted the child to travel with to the US between the dates of July 6th and December 31st. At trial, a Romanian lawyer actually testified that the affidavit did not permit the father to permanently relocate the child from Romania. And to do that, he actually would have had to gone to a Romanian court and gotten a guardianship order. While the family's original travel to Romania was only intended to be temporary, during the 10 months after the child's birth, the court concluded their intent shifted. In October 21st of 2021, the US Court of Appeals for the Fifth Circuit affirmed the Eastern District of Louisiana in its denial of Mr. Christopher Harm's request to return his child to Ireland using the Hague Abduction Convention. The child's mother was a musician, and even though the family had originally intended to set up home base in Ireland, She was barely there. She was off traveling through Europe and the United States. Despite some evidence that Ireland was home, including social media accounts, toddler groups, driver's licenses, residency status, the trial judge was, of course, entitled to significant deference under our clear error standard, and the circuit court would not overturn the trial judge's conclusion because they didn't commit that clear error. I have one editorial if you actually go and read the harm opinion. The court said a lot of incorrect things, although those things were actually not germane to the outcome in the case. But it's important that if you read this opinion, you don't rely on the incorrect statements. And for example, one of the most prominent ones is that the Fifth Circuit indicated that it was being asked to decide which country had jurisdiction over this child's custody. And that's unequivocally not what the Hague Abduction case is about. The Hague Abduction Convention is only to seek the return of a child who's been abducted. Domestic law is actually what dictates child custody jurisdiction, or if your country has the 1996 Hague Child Protection Convention, that's helpful as well. That we don't have that in the US, but we do have the UCCJEA, and we'll get to some of those cases soon. Okay. So a parent seeking his or her child's return under the Hague Abduction Convention also needs to prove that the parent has a right of custody under the law of the child's habitual residence. And on March 4th of 2021, Judge Liam O'Grady of the U.S. District Court for the Eastern District of Virginia entered an order in the case of Alaker versus Jan, granting Ms. Jan's motion for judgment on partial findings. The key issue in this case was whether Mr. Alaker had a right of custody, and Judge O'Grady determined that he did not. The Alaker-Yan family left the United States in September of 2017. In November of 2018, over a year later, the parents signed a separation and property settlement agreement that said Ms. Yan would have sole legal and sole physical custody of the children. The document included a choice of law provision that construed the agreement under Virginia law, but the parties actually executed the agreement while they were residing in and physically present in Portugal, where they were living at the time. At no time was the agreement incorporated into a custody order in any jurisdiction. In May of 2019, Mr. Alaker filed custody proceedings in Portugal, which is presumably the children's home state under the UCCJEA. On October 3rd of 2019, Ms. Yan emailed Mr. Alaker and advised him that she's taking the children to the United States to reside, and she actually departed the same day she sent her email. On September 24th of 2020, shy of 1 year after the wrongful removal, Mr. Alaker filed a return petition under the Hague Abduction Convention. The parties stipulated to the validity of the agreement. Article 3 of the convention confers a right of custody under an agreement, quote unquote, having legal effect. And Mr. Alaker argued that the agreement actually had no legal effect under the law of the habitual residence. Renvoi dictates that Portuguese law would actually apply Virginia law, which is the law of the common nationality of the parents. And Mr. Alaker argued that Virginia law actually requires an agreement to be incorporated into a court order in order to have legal effect. He lost in a per curiam unreported opinion in the Fourth Circuit. He actually filed a writ for a petition for a writ of certiorari to the US Supreme Court, proximate to Thanksgiving here in the US. So it's to be continued as to what is going to happen next for that particular family. So the final thing a parent needs to prove, a petitioning parent, to seek the return of their child is that they were actually exercising that right of custody. And in the case of Jones v. Fairfield, the Eastern District of Washington actually denied Mr. Jones' request to have his child returned to France because the judge concluded he wasn't exercising his right of custody, because Ms. Fairfield and the child were living in a homeless shelter, and because she didn't have funds to pay for other lodging. And the court concluded that this mere undisputed fact that Ms. Fairfield was living in a women's homeless shelter alone suggested that Mr. Jones intended to cut off all financial support to the mother and the child, knowing that the child would suffer. However, in the Ninth Circuit, in September of 2021, the court vacated and remanding, saying that cutting off financial support is just insufficient to establish that Mr. Jones clearly and unequivocally intended to abandon his child. So a respondent parent has several arguments against returning their child to the child's habitual resident. One such argument is that the child is mature and has objected to being returned. Overall, I actually saw a lot more of these cases in 2021 than in prior years. So I wanted to go through a few of them, which I thought were very interesting here in the United States for a country where some lawyers are concerned that perhaps a child's voice doesn't play a prominent role in litigation. So on January 7th, 2021, in the case of Dubakovsky versus Gown, the US District Court for the Western District of Missouri denied Mr. Dubakovsky's request to return his daughter to Switzerland. The child was age 12, had not lived in the United States since age 3. The court spoke with the child twice, and between each of those times had an evaluation of the child, and concluded that the child had entered puberty, had a strong personality, was substantially above intellectually above average, and had a well-developed sense of responsibility for her half-sisters and other individuals. So even though English was not her first language, she expressed herself very maturely. She gave particularized reasons for opposing return to Switzerland, and those reasons were in line with more of what an adult might consider when they are choosing a residence. And those reasons included her responsibilities, the comfort of each place, the opportunities to pursue her goals and activities that had meaning to her. The court then looked at whether it should nonetheless use its discretion to grant Mr. Dubakovsky's petition despite the child's objection. It had some really harsh words for Ms. Gown about her actions in retaining or removing the child, but it concluded that the child was the innocent party and should be permitted to remain in the United States because of her objection. On November 19th of 2020, the US District Court for the Middle District of Georgia issued an opinion. It denied Mr. Romero's request to return his 2 children to Chile. The oldest child was age 14 and was interviewed in camera in chambers and described her desire to live in the United States where she felt safe. And she elaborated on her life in Chile where she did not have enough money, frequently had to change residences, and constantly lived in fear that the petitioner would break into where they were living and hurt the respondent. The court said when determining whether the child's objection is the result of undue influence, the district court considered whether the objection was derived from the child's own independent thought, whether the child displayed honesty and fairness when describing her parents, whether the objection was based on the child's personal experiences, and whether the child provided specific reasons for the underlying objections. Mr. Romero appealed, but in May of 2021, the 11th Circuit affirmed that the child would not be returning because of her objection. In Avendano versus Balsa, the First Circuit affirmed the US District Court's refusal to return G, a minor child, to Venezuela on the basis that G was mature and objected to the return. The petitioner mother appealed the court's finding on 2 points, arguing the court wrongly concluded the child was mature and that the child was not unduly influenced. The trial judge had examined a variety of witnesses who had observed the minor child's demeanor, her testimony, and even heard from the child's guardian ad litem, and interviewed the child personally in the guardian ad litem's office before concluding that the child's desires were very clear, consistent, and rational, and that he not only stated a preference for the United States, but clearly objected to being returned to Venezuela. The court rejected the petitioner's argument that the court should have examined the child's maturity at the time of the wrongful retention instead of at the time of the evidentiary hearing. So another child that did not get returned. On March 15th, in the case of De Jesus Hoya Rubio versus Alvarez, the US District Court for the Southern District of Florida denied a father's petition to have his 12-year-old son returned to Mexico. The mother retained the services of a psychologist to evaluate the minor child and ultimately demonstrated that the minor child was mature, objected to returning to Mexico, and was not unduly influenced. The child, with interventions that were available to him in Florida, was able to maturely articulate he was happy. He was receiving an IEP that helped him tremendously in school in Florida, and he felt that he was in a better place to learn based on his attention deficit hyperactivity disorder treatments. The child was also able to share that he knew that regardless of being in the United States, he was going to continue seeing his father and having a relationship with him, and that he had a strong family bond to his younger brother and the family in the United States. So he was not returned. But there is one more final case that I thought was interesting to share. And in late November, the Second Circuit affirmed the Southern District of New York's order to return 2 children to Israel in the case of Velozni versus Velosney. The Southern District of New York judge refused to interview the 2 children in camera because they had already gone through hours of interviews with a forensic psychologist. And that forensic psychologist testified, and the judge felt that there would not be any significant additional evidence that would be determinative coming from an in-camera interview of the children. And so the children were decided to not be returned despite what was argued as an objection. So one of the most commonly argued exceptions to returning children, at least in the United States, is that doing so would put the child at a grave risk of harm or in an intolerable situation. Some US circuits, even upon a finding that a grave risk of harm exists, are required by past precedent to examine whether there are things that can be put in place to ameliorate the risk so that the child can nonetheless return. And that is the issue at the heart of what will be the 5th US Supreme Court case of this, of the time we've been treaty partners. Actually, the last one was the Manaski case in 2020. So Golan v. Sada will be heard at some point this calendar year, perhaps as early as March. On January 26th, Ms. Narkis Golan filed a petition for writ of certiorari to the US Supreme Court. The Eastern District of New York had concluded that there was a grave risk of harm to the child if the child were returned to Italy, but that there were certain things that could be put in place or were already in place that would ameliorate that grave risk. At the end of several appeals, the return order stood and still stands. Ms. Golan presented the Supreme Court with the following question. Despite a finding of grave risk, is a court required to consider ameliorative measures that would facilitate the return of a child? Ameliorative measures is the Second Circuit's verbiage for what are otherwise called undertakings and protective measures. Undertakings are things that the parent in the habitual residence agrees to do to protect the child. Protective measures tend to be things that just exist in the habitual residence, like a functioning court system, social services, ability to get protective measures, medical care, things that could ameliorate that grave risk. So on December 10th of 2021, the Supreme Court did in fact grant Ms. Golan's petition. The acting Solicitor General of the United States included some language toward the end of its brief that seems to indicate it wants the Supreme Court to not only strike down the Second Circuit's mandatory consideration of ameliorative measures, but for the Supreme Court to give guidance on judicial discretion and when that should be exercised to return children. The treaty permits a judge the discretion to return a child at any time, despite any argument the taking parent may make. Okay, so while many cases argue a grave risk of harm, besides Golan v. Sada, there was actually a Ninth Circuit case that melds well with that discussion of ameliorative measures. In September of 2020, the US District Court for the District of Arizona ordered that Mr. Radu and Ms. Shawn's 2 children be returned to Germany. But because the court concluded returning the children to Mr. Radu would present a grave risk of psychological harm, the court actually ordered that Ms. Shawn shall retain temporary custody and care of the children until a custody determination can be made in a German court of competent jurisdiction. Ms. Shawn appealed. She argued that the court exceeded its authority, including requiring her to move to Germany, resolving, albeit temporarily, custody of the children in a Hague abduction case, setting up a situation where she was required to file a custody suit in Germany, and necessitating the German courts resolve custody over the children. The Ninth Circuit issued its opinion on August 31st, vacating and remanding to the district court. It reaffirmed that when a court finds that there is a grave risk, it must determine that whether there's alternative remedies, their form of ameliorative measures, that can safely repatriate the child, and it needs to determine whether and how the alternative remedy is likely to be performed in the habitual residence. The circuit court vacated and remanded, requesting more supporting evidence on whether the order returning the children in Ms. Jean's custody had a high likelihood of actually being performed in Germany. The trial court took additional evidence in November, a few months ago. Towards the end of November, Ms. Jean filed a petition for writ of certiorari to the US Supreme Court, making a similar inquiry about ameliorative measures that Ms. Golan had made. But she also raised a second issue left unresolved by the Ninth Circuit, and that was which parent has the burden of actually proving the ameliorative measures. At the end of December, so a mere few weeks ago, the trial judge issued a new order, again returning Ms. Jean's children, after hearing from a German law expert as to the unenforceability of the court's temporary custody order in Germany, and after speaking with the German Central Authority under the Hague Abduction Convention. Proximate to the court's order, Ms. Jean requested that her matter be heard by the Supreme Court parallel to Golan v. Sada. And we're not yet sure whether the Supreme Court might take that up. Hopefully we'll know in a week or two as to whether or not that will be heard parallel or whether it may be paused in the Supreme Court until Golan v. Sada is resolved. So, grave risk of harm cases are not always about domestic violence. The language in the treaty is actually broad enough to encompass much more than just domestic violence. In an interesting grave risk case, Ms. Wan sought the return of her 2 minor children to Hong Kong from Illinois. Among other arguments, Mr. Dibolt argued that it would be a grave risk to return the children to Hong Kong because he perceived the climate of Hong Kong to have changed over the past few years after the British transferred Hong Kong to China. With significant political protests and fear of reprisal by the government for expressing political views. He argued that Hong Kong no longer guarantees individual rights and the children will always have to look over their shoulder, and that children are specific targets of the national security law passed by China for Hong Kong in June of 2020. And he thought that the law would be taught in schools in Hong Kong, and China's crackdown on dissent was a threat to the children. But the court concluded that his concerns were just generalized risks and not sufficient to demonstrate a grave risk, specifically that these children actually didn't go out and protest, and neither did their mother. Finally, the Ninth Circuit vacated and remanded the Western District of Washington in Colchester versus Lazzaro. Ms. Lazzaro argued the grave risk of harm exception and requested the appointment of a psychological expert to demonstrate the impact of the abuse on the child and meet her burden of clear and convincing evidence, which is the very high burden that we have under our implementing legislation to prove a grave risk. The trial judge rejected her request and set in a 4-day trial without allowing her to have a psychological expert appointed. While Ms. Lazzaro had a Spanish psychologist testify, that person had really limited information. And so, taken up on appeal, the Ninth Circuit concluded that even though there's no right to the appointment of a psychological expert, in this case, it was error in that it prevented Ms. Lazzaro from fully presenting evidence of her exception on a grave risk. Prejudice is established if there's a reasonable probability that the outcome would have been different had the discovery been allowed. The court made a final comment that the remand for an expert appointment was not a prejudgment of her argument. She still has to meet her clear and convincing burden. So most practitioners really do focus heavily on the language of the Hague Abduction Convention that relates to a wrongfully removed or retained child. Very rarely do we see the part of the Hague Abduction Convention invoked in the US courts that relates to access. The language in the convention in Article 1B also includes a second objective of this convention, and that's to ensure the rights of custody and of access under the law of one contracting state are effectively respected in the other contracting states. And more colloquially, this is really the Hague access case, which we don't really see much of. Article 21 of the convention says an application to make arrangements for organizing or securing the effective exercise of rights of access may be presented to the central authorities of the contracting states. in the same way as an application for the return of a child. So presumably that language implies that it should look very much the same as if you were seeking the return of a child. Generally speaking, however, US federal courts, where most of these cases are filed, have determined that access claims, the schedule to see a child, a parent seeing a child, is better addressed by a family court. As you know, under our implementing legislation, state and federal courts have concurrent jurisdiction to hear a Hague Abduction Convention case. So this is the backdrop of where Mr. Dawson found himself in Colorado. Mr. Dawson and Ms. Dilla's child was born in the United Kingdom. Ms. Dilla was granted permission by a Manchester family court to relocate to the United States. The court issued a custody order giving Mr. Dawson certain access rights to the child. The family, after relocation, continued litigating in Manchester and in Colorado's family courts. Both courts actually issued some subsequent orders to some extent. And then Mr. Dawson apparently didn't show up to a Colorado family court hearing. And so the Colorado family court issued a warrant for his arrest. And it was at about this moment that he then went to the federal court, not the state family court, and filed a Hague access claim, asking for the federal court to enforce his access rights under the Manchester parenting order. The federal court concluded that there was no abduction, and it had no authority to do anything under the Hague Abduction Convention, and it denied his request for a Hague access enforcement. It suggested that the appropriate venue to recognize and enforce access rights was the Colorado Family Court or the Manchester Family Court. The 10th Circuit then issued an opinion in the same case, concluding that this case was actually precluded. Mr. Dawson's case was precluded by the Younger abstention doctrine because there was ongoing litigation already in the family courts on the precise same issue. So he was out of luck. He needed to go back to the family courts where, of course, there was a warrant out for his arrest in Colorado. So that actually brings us very nicely to the next topic that I'm going to discuss, which is custody. The Uniform Child Custody Jurisdiction and Enforcement Act determines child custody jurisdiction in the United States. The UCCJEA provides for a prioritized list of obtaining jurisdiction to render an initial child custody order. The priority basis is the child's home state. Home states where the child's lived with a parent or a person acting as a parent for the 6 months immediately before the filing of the lawsuit, minus any temporary absences. Only if there is a home state or the home state declines to exercise jurisdiction, only if there's no home state or the home state declines, then does a practitioner or a court go on to the next basis for actually determining whether or not there's jurisdiction under the custody statute. So in this particular case, in matter of Saida, the New York County Family Court concluded that a child was temporarily absent from her home state of New York so that New York Family Court could actually proceed with its custody case. The minor child was repatriated by the US Department of State from Pakistan to New York on June 26th of 2020 at the age of 16 because of concerns that she'd been brutally beaten and coerced into an arranged marriage in Pakistan. The child is a US citizen. She had lived in New York prior to being taken to Pakistan by her father. The father left the child in the mother's care in Pakistan. When the child returned to New York, she was placed in foster care in the care of the New York City Administration for Children's Services. And 3 months after her return, not the 6 months for home state, an abuse petition was filed against her parents by the state. Her parents filed a motion to dismiss the abuse petition, claiming that Pakistan was her home state. That's where she had lived for the 6 months with a parent or a person acting as a parent. The father requested that the child be transferred to social services in Pakistan. And New York Children's Services argued that the UCCJEA need not apply because Pakistani child custody laws as written or as applied violate fundamental principles of human rights. It cited to a 2019 State Department report, reports from Human Rights Watch and Amnesty International finding that child abuse is widespread in Pakistan and child marriages occur despite legal prohibitions. The trial judge denied the motion to dismiss and considered Pakistan a temporary absence from the child's home state of New York. The father admitted that he brought the child to Pakistan merely for a vacation, and her return was delayed because of medical issues, hospitalization, and COVID-19. There were unused return plane tickets, and the child was never unenrolled from her New York high school. If the forced marriage allegation is true, and then there was a wrongful retention of the child over in Pakistan, then a temporary absence is an appropriate argument to have been made. Alternatively, the court said temporary emergency jurisdiction once the child was back in New York State would actually be an appropriate basis for jurisdiction as well. The court rejected the human rights argument because Children's Services did not cite to any Pakistani law that permits the behavior outlined in the various reports that it cited. So if a foreign country's child custody laws violate human rights, then a US court, when it conducts its UCCJEA custody jurisdiction analysis, need not treat the foreign country as if it were a sister state. On February 8th, the Superior Court for Chelan County, Washington, issued a memorandum opinion on the case of Al-Hadari versus Al-Hadari. The child was born in Saudi Arabia in December 2014 to Bethany and Ghassan. The parents were in the middle of custody litigation in Saudi Arabia when Bethany, under the guise of reconciling, secured Ghassan's permission to visit her family in Washington state with the child. After arriving in Washington state, she sought a temporary emergency parenting plan and restraining order. Saudi Arabia in this circumstance is very clearly the minor child's home state. There is already a pending custody case in Saudi Arabia. The home state has not declined jurisdiction. There are custody orders from the Saudi Arabian courts. The Washington court, however, concluded that the Saudi custody determination did not follow any standards set forth in any Saudi law because there's no set codified child custody law in Saudi Arabia. Given the lack of codified laws, it was difficult for the court to determine if Saudi child custody laws violate fundamental human rights. And so the court turned to examples of custody orders handed down by the Saudi courts to determine whether or not, more generally speaking, human rights are violated by child custody laws. The court concluded that Saudi custody laws do violate fundamental human rights, that women were not treated equal to men, that non-Muslims were not treated equal to Muslims, that non-Saudi citizens were not treated equal to Saudi citizens, and that the inferior classes of individuals are denied basic due process rights, including the right to a fair and impartial tribunal. Now, I have been trying to locate any subsequent appeal in this case, but have been unsuccessful. So if anyone is aware of one, please send me an email because I would love to see what's been happening in this case for this family going forward. The UCCJEA also includes interesting provisions that allow a foreign custody order to be easily registered and enforced in the United States. Ms. Zhao and Mr. Wang are parents to a daughter born in 2013 in China. Mr. Wang worked in California and the child lived primarily with the mother in China, but visited with her father in California. In 2016, Mr. Wang sought an emergency temporary order in California to prevent the child from returning from California to China, but the parents engaged in negotiations. They reached several agreements later, and the child went back to China, but with an actual outline of scheduled visits to California for the child to see the father. The parents both acknowledged that China had jurisdiction under the UCCJEA and that they would register or mirror the California temporary order in China. In 2018, a Chinese court issued then a subsequent custody and divorce ruling. After it held a trial, it gave Ms. Zhao sole custody of their daughter, clearly contradicting the California agreement that was made into a court order. It gave Mr. Wang visitation on the third Saturday and Sunday of every month in China. Ms. Zhao sought to register the Chinese custody order in California. She was actually unsuccessful because the execution of the order was stayed pending Mr. Wang's appeal. He had appealed in China, and so it wasn't a final order that could actually be registered in California. The Texas Court of Appeals also addressed registration of an order recently. It affirmed its trial court's registration of an ex parte Mexican custody order. In this case, Ms. Covarrubias Campos obtained an interim ex parte custody order. Mr. Tucker argued he had no notice of the Mexican proceedings and therefore no due process in the proceedings. A court order should not be recognized as a matter of comedy in US proceeding if there's no due process. Determining what due process is actually afforded to the parents is measured by a flexible standard, and it actually depends on the practical requirements of the circumstances of that particular case and family. Mr. Tucker doesn't debate that the Mexican courts have jurisdiction, that it's in substantial conformity with the UCCJEA, that Mexico is a child's home state, and that it issued an emergency order, and that he actually had notice of that order a few days after it was issued so that he could contest it in Mexico. Texas courts permit these type of ex parte emergency orders without violating due process. Further, the plain language of one portion of the UCCJEA cited by Mr. Tucker does not require notice unless Mr. Tucker met his burden to establish that he was entitled to notice in the Mexican court proceeding itself. The trial court found that Mr. Tucker was not entitled to notice in the Mexican proceeding prior to the Mexican order being issued. And so Mr. Tucker did not cite any evidence to meet his burden to establish that he was entitled to notice under Mexican law. So this order was registered despite the fact that it was ex parte and he didn't participate in the proceedings. Okay, I'm going to hurry myself up. I'm going to actually skip this because I want you to be able to get to some interesting law from across the pond. So US divorce jurisdictions based on domicile. This is not so with many other countries, which may choose to base their jurisdictional principles on other connections to the couple. Still separate from where a divorce is resolved is the law that actually applies to resolving the issues related to the divorce. In this case, Mr. Ajay and the US government filed cross motions for summary judgment in a recent case before the US District Court for the Eastern District of Virginia. On March 23rd, the court granted the US government's motion for summary judgment. This case actually revolves around the US immigration system. The USCIS denied Mr. Ajay's 2014 application for naturalization. The key argument that the government used to deny his application was that his wife was not legally divorced from her first husband when she then married him. And therefore his marriage, which is what the application was based on, is void. Mr. Ajay's wife married her first husband in 1996 in Ghana. She lived there for 3 years before moving with her husband to the United States. And while both of them were actually domiciled in the US, she divorced her husband according to Ghanaian law in April of 2001. The divorce had actually involved the wife's father and the husband's uncle submitting declarations of the divorce, later confirmed by the Ghana courts. In April of 2001, Mr. Ajay then married the wife, and he petitioned for his permanent resident status a few months later. But the court concluded that because no one had been domiciled in Ghana at the time that his wife sought her divorce in Ghana, that it would not be recognized and not entitled to comity by the US. And so poor Mr. Ajay cannot use his marriage to this woman who was already legally married to someone else as the basis for his immigration. And I think this is going to be my final case, which is just fascinating. In the US, bigamous marriages are void against public policy. So it's important to analyze when a marriage legally ended and when a new marriage legally began, as we just saw for the poor gentleman whose wife divorced in Ghana. So a fascinating case came before the US tax court this past year, concluding that Ms. Ziona Grossman, the third wife of Mr. Simone Grossman, was his surviving spouse under the Internal Revenue Code. Mr. Grossman married his first wife, who was Jewish, in New York in 1955 and separated 10 years later. He obtained a unilateral divorce in Mexico where no one was domiciled. 2 years later, he married his second wife in a civil marriage ceremony in New Jersey. And then 8 years later, that relationship ended. At about the same time, his first wife sued him and his second wife, seeking declaratory judgment that the Mexican divorce was null and void. She won, of course, and was declared his lawful wife. So we're back to wife number one being the lawful wife, because the second wife could not be the lawful spouse, given that he couldn't remarry until he was legally divorced from the first one. In 1986, Mr. Grossman then became engaged to his third wife, Ziona, who was also Jewish, and they planned for a wedding to occur in Israel. Before that marriage, Mr. Grossman and his first wife appeared before an Orthodox rabbinical court in New York to obtain a Jewish religious divorce, evidence which was presented in Israel so he could then marry the third wife. Mr. Grossman and his third wife lived happily in New York for 27 years until he died. At no time did the first wife challenge that marriage, and then comes along the Internal Revenue Service. They took the position that Mr. Grossman's religious divorce from his first wife was invalid under New York law, and therefore she was still the lawful and surviving spouse. His estate disagreed, arguing that New York law is irrelevant to the dispute and that the court should be looking at Israeli law. Why do they care? Why does the IRS care? When his estate filed its tax return, it took a marital deduction with respect to assets that it bequeathed to the third wife, which was approximately $79 million. In March of 2018, the IRS commissioner sent the estate a notice that it was deficient by about $35 million in its federal estate tax. It also assessed an additional deficiency of $7 million. These deficiencies related predominantly to the fact that the IRS determined that the third wife was actually not the lawful spouse and that he was still married to his first wife. So whether a person is a surviving spouse is determined under the law of the state where the estate is being administered. The court looked briefly at Israeli law. For Mr. Grossman and his third wife to marry in Israel, they had to demonstrate that all prior marriages were dissolved by death or divorce. And since two Jews marrying in Israel would do so in a religious ceremony, the only means of obtaining a legal divorce that had effect in Israel is through a get, a religious divorce. A civil divorce had no effect on the individual's eligibility to remarry under Jewish religious law. Mr. Grossman and his first wife obtained a get from a rabbinical court that was recognized in Israel, which permitted them under Israeli law to legally marry. So the commissioner argued that Mr. Grossman and his first wife's get under New York law by a New York rabbinical court was not legally sufficient, that they needed a civil divorce in New York. The estate and the tax court disagreed. They instead looked at New York's law's application of lex loci celebrationis. A marriage, if valid where celebrated, is valid everywhere. And short of some public policy to the contrary, that's the rule. So Mr. Grossman and Ziona were legally married in Israel. Israel deemed Mr. Grossman and his wife number one divorced by a way of New York rabbinical court, and that was sufficient to legally allow him then to marry wife number three. Bigamy is also illegal in Israel, and Mr. Grossman's lawful spouse is number three. She's the surviving spouse. She was entitled to take the surviving spouse tax deduction. So I am going to be done because I'm going to turn it over to my more interesting counterpart. I'm going to stop sharing my screen so he can then share his.
Not sure how you could say that. Mr. Grossman seems to have kept everyone very busy indeed with all his wives. And to think he said that there are no interesting cases. I do feel for you. You've got a hell of a job considering you've got 50 odd jurisdictions to summarize, and we've been everywhere from Louisiana to DC to Washington State, whereas I've just got one tiddly little jurisdiction to summarize. But hey, thank you for that. That was brilliant. Now I will just load up my one. Hopefully you can see that. Great. So for those of you who I have not met digitally, my name is James. I'm a partner in the children team at the International Family Law Group in London, where we specialize in all weird and wonderful cases involving children. So today I've been asked to talk about some of our bigger cases from the year that's just gone by. So today we will be discussing a review of Hague Convention case law and recent developments. Article 13b, which may be of interest, especially to the Golan Sada case, if it's trundling its way off to the Supreme Court. Refusal to return in Hague Convention proceedings and changes of circumstances. Of course, this being 2021 to 2022, we have to go through COVID and the effect it's having on international family law. Sadly, this was not something that we left in 2020, but here we are 1 year later summarizing exactly the same principles. And then a few other slightly more left field cases, if I may, including adult children claiming maintenance from their parents, a bit on diplomatic immunity, and a case that we'll see of the Al Maktoum family dramas in due course, as well as ISIS, family law, and the involvement of the European Court of Human Rights. So no big deal to summarize in 45 minutes. But first, for those of you who attended the presentation last year, you may remember that I started by discussing this case of G&G, which was going to our Supreme Court. And it just so happened that this case was the judgment in this case was due to come out, I think it was 2 or 3 days after I gave my presentation last time. So I know you've all been waiting, bated breath to find out how it concluded. It was, I think, the only Supreme Court case dealing with child abduction matters last year and for a good few years. But in very brief terms, it was a case concerning a South African family with a South African child. The child and mother and father lived in South Africa, and the mother stated that she began to experience persecution from her family in South Africa as a result of them coming to learn that she was a lesbian. She fled to England with the subject child, G, referred to as G in the judgment, and made an asylum application in the UK when she arrived. And this was in February 2020, and then the father issued an application under the Hague Convention for the return of the child to South Africa a few months later, unaware that this child was subject to an asylum application. And this potted around the High Court and then the Court of Appeal, and eventually went to the Supreme Court. And in this case, the Supreme Court did hold that a child applicant for asylum cannot be returned, so there was non-refoulement, to use the words that the Asylum Convention uses, from the country from which he or she has sought refuge from before the final determination of the asylum claim. Now, this has set the cat amongst the pigeons, I may say, in abduction proceedings. We now have this bizarre situation where respondents in Hague Convention cases who are trying to be a little bit savvy, a little bit clever, or really determined and not going back to their countries of origin are claiming asylum whilst in England. It's been a bit of a nightmare, and we are seeing lots of different asylum cases from here, there, and everywhere. There's one that I'm aware of that's trundling through the court, where the mother very blatantly abducted a child from Singapore and then claimed asylum in England from Singapore. The same has happened in this South African case. I'm aware of another case that we'll discuss in a moment, which is from the European Union. And finally, there is a case going around that I've heard on the grapevine of a mother who abducted from California, and she's claimed asylum in England. And I can't speak for her claim or what the Home Secretary will do with that asylum claim, but we'll take it one step at a time. I'm not really sure if a Californian asylum claim is the strongest in the grand scheme of things. But the court is now dealing with these situations whereby determined abductors now launch asylum claims, either on their behalf or on behalf of the child, I should say, in order to torpedo any chance of going back to their countries of origin. Now, there's this cat and mouse game where if you're for an applicant, you'd certainly try and get the Hague Convention application dealt with expeditiously, as quickly as you can, and then get that decision and send it to the Home Secretary. The Home Secretary is the person who's deciding whether an asylum claim can be granted. If a judgment of a family court says that this child should go back to their country of origin, then, well, that surely might determine whether an asylum claim should be granted or not. The problem then becomes when applicants start appealing, or if there's a process for review, and that in itself can delay things monstrously. And on the background of all of this, you might have a child who's getting older and older. He or she may object. The objections may strengthen. It may be impossible to implement a return order. It's just a real a Pandora's box here when you start analysing some of these issues. There have been a few cases that have trickled through of note. The first one being Riel, and this was a mother who claimed asylum and diplomatic protection, humanitarian protection, I think it was, from with her daughter, and the daughter applied of her own right, despite being quite young. I think she was 6 in this case, and she was escaping alleged persecution from the state of Hungary in the European Union. Now, putting it this way, under our previous EU legislation, which came to an end when we left the European Union, Article 11.4 said that it would be difficult to establish a 13B between European Union member states if you had sufficient protective measures. Well, that was something that this mother was trying to do within the Hague Convention, within the Hague Convention proceedings. Perhaps unsurprisingly, this was refused by the Home Secretary. She had made an application for a judicial review of that decision. And then in this decision, Richard Harrison, QC, sitting as a Deputy High Court judge, he said that an application for judicial review does not in it of itself confer automatic protection from refoulement and order the child's return to Hungary. Now, there's a further case, which is a Russian case called Rike, a child stay of return order asylum application. And this is where a judge was determining whether a child should be returned, if the return order should be implemented, whilst there is a pending claim. And in that case, there's talk of the father's application. The father had abducted the child in that case from Russia. If the father's asylum claim being a sham application. Now, the judge doesn't hold that it's a sham application, and I think it would be quite dangerous for a family court judge to step on the toes of the Home Office and the whole immigration procedure to do so. But to quote his judgment, he says that this application has all the hallmarks of a father seeking to ambush the mother with a last hope application. So he doesn't call it a sham, but he calls it a sham. But either way, the family court here did say, or the High Court, I should say, says that whether an asylum claim is legitimate is a matter to be decided by the Home Secretary. So no great surprises there. And then finally, how does this all mix with non-Hague Convention applications? Well, to leave you on a cliffhanger, again on the asylum front, there is currently a non-Hague application going through the courts of children being returned to Nigeria, where a claim for asylum has been made, and there are quite significant allegations of FGM, and that's the case my colleague Helen is doing, and we should be getting judgment within the next week or so. So watch this space. That might be something I am reporting back to you all this time next year. But moving away from asylum, the next bit is Article 13b and abduction. So this case, this ABCD case, was one of the first of 2021, and it was an application for the return of 2 children to Kazakhstan. There were some reports, some allegations of domestic violence, and you can see within the judge's judgment just what he makes of them. Although he does ultimately proceed on the basis that the mother had suffered these significant verbal and physical, suffered significant and verbal physical abuse. The judge took it at its highest, but interestingly, there was a report that said that any undertakings offered by the father were not going to be enforceable automatically in Kazakhstan. There was no requirement in law, according to this judge, that the undertakings must be enforceable, and the court had no cause to doubt the father's character, his bona fides. Certainly, if I was acting for the father in Golan Sada, I'd be pinning this case to the Supreme Court's door in the US. It's quite an interesting one, and the judge does analyse the law in this area. This undertaking thing as well is quite an interesting dimension to the case as well, because certainly amongst us Anglo-Saxon lawyers, the US and in the UK, an undertaking is something we deal with very, very regularly. However, if we were to refer an undertaking to, say, a Spanish or an Italian or a Chinese or a Greek lawyer, their understanding may be very different or non-existent. So this whole principle is something that the English system has put to bed quite easily with this non-enforceable point, but it does vary on a case-by-case basis. Interestingly as well, the return of these 2 children was hampered somewhat in that it transpired the mother had applied for asylum after, and that's referenced as a postscript in the judgment there. Then secondly, there's the case of Rie, which is our Court of Appeal, a Court of Appeal decision. This was a return of a young child to Virginia, and the proceedings, there had been some proceedings in Virginia that were really quite messy. There were some custody proceedings, quite serious allegations of domestic violence. Then the parents got back together, and the mother then withdrew her proceedings in Virginia. She came over to England, she retained the child, and the father sought the return of the child to Virginia. The High Court dealt with this case, and the mother was making quite serious allegations of domestic violence and saying that this all affected her mental health. There was an article, there was a psychiatric report about how her mental health would be impacted if a return order was made. But notwithstanding this, and partly due to the fact that this was Virginia, I've got to say, the return was ordered. The mother sought to appeal this, and the mother appealed this to the Court of Appeal, and annexed to her application was a new letter or report from her doctor that said that her mental health was deteriorating, or had deteriorated post the making of the return order. And the judge, notwithstanding the fact that the judge at first instance had dealt with this case with belts and braces and ordered the return subject to the implementation of a child custody order and the implementation of injunctions in the local family court in Virginia, The matter went to the Court of Appeal, and the Court of Appeal overturned the whole thing and sent it back for a rehearing. So it is still something that we grapple with very, very regularly, this Article 13b, through the prism of mental health of respondents. And this case doesn't really, sort of muddies the water somewhat in relation to that issue. The next issue is that of when a parent refuses to return with a child. So this was a matter that went to the Court of Appeal as well, called Re-C, and this was the decision of Mr. Justice Cohen, as he was then, where the parents had been battling it out quite vigorously in the Paris Family Court for many, many years. And the decisions of the French courts talked about the father's being bipolar, having some sort of bipolarity, and the mother being exceptionally irrational with regards to handing this child over to the father for some contact. And the French court was highly concerned by the effect of this conflict on the child. Lo and behold, the mother had abducted this child from the UK to England, from France to England, and the father sought for the child's return. The mother set out her defences of 13b and objections, but curiously, she also her stated position was that she would not return to France with this child if it were ordered. And this is not a case where she could not, for example, by way of an immigration issue or for a pending criminal claim against her in France. It was simply because she just would not. That notwithstanding, the High Court ordered the child's return to France, and the mother appealed this, averring that the trial judge, was wrong not to allow oral evidence in this issue. I suspect that the mother and her legal team probably wanted to throw her in the witness box so the judge could hear from her about not wanting to go back to France. The judge held that the child should be returned, said that there was no risk of harm if she were returned, if the child were returned with her, and recited that as the mother is a loving and devoted mother, she should return as well. This is in stark contrast to cases involving the US, for example, where there have been immigration issues and a parent cannot enter the jurisdiction or cannot stay there. Here was that she just simply wouldn't, and she was, to use a common phrase used in these courts, holding a gun to the court's head and saying that she wouldn't return. On appeal, the appeal was dismissed, it was upheld, and the return order was upheld. The judgment is quite interesting as well, because it's one of the further judgments that's really referring to the Hague Convention's Committee's Guide and Good Practice. It's quite a good few little sound bites in there. This crops up in one of your cases, and the appeal was dismissed. By contrast, if you look at the case of LC, which is a slightly older case, the mother was refusing to return to Zambia in an application where she was the primary carer of 2 children, and the father had sought for the return of children from the UK to Zambia. She said she wouldn't return, and Mr. Justice Holman accepted that the mother would not return and refused to return the children for various reasons, but did cite the non-return of the mother, the primary care mother, as one of them. And he does state in that judgment, in Hague Convention proceedings, I'm paraphrasing here, but in Hague Convention proceedings, the court deprecates mothers holding guns to the court's head, but I am not in a Hague Convention case, and goes on to justify his thinking in that respect. So otherwise, in terms of abduction updates, there is another case of ES and LS, and this was a Latvian case. And this is Mr. Justice Mostyn dealing with a case with characteristic vigor and forcefully here, where he does say that Hague Convention applications have become disproportionately complex, lengthy, and expensive, and full of obtuse legal points. He said that the cases that involving the Hague Convention occupy an unreasonable amount of the High Court's resources. There was a question within this case as to whether oral evidence should be allowed. In this case, the children had been in the UK for over a year. They were joined through a social worker guardian. The social worker guardian said that the child was settled, and those who acted for the applicant father sought to cross-examine the guardian on this point. And there was it seems like there's a bit of sparring in courts about this very issue. The judge does make an interesting comparison about the issue of settlement, which he distinguishes from an older case of Bracewell J on the issue of when a child should be settled and when the point is now, as per the Hague Convention. Is it the date of the application? Is it when the judge is considering the case? I think that's rife for an appeal if people follow that, because judges the court system itself can take far longer than 6 weeks to determine a Hague Convention application, by which time a child may become settled. But he does leave that open. And interestingly, another little helpful soundbite of you representing a elder child, 13, 14, 15, as was the subject of this application in ES. In that case, he said that due regard should be had to the universal policy that underpins the Gillick principle, namely that a child who has achieved a sufficient degree of maturity should have her decisions about her life respected, provided they are not foolish or irrational. And Gillick is quite an old case that we use very frequently in this country about when children who are competent to make their own decisions, when this should be taken into account. And he does say that children should not be forced back when they are Gillick competent. And that's something that is also going to the Court of Appeal, I am aware of, in the next few weeks. So, as I say, watch this space and we'll keep ourselves posted. So, on the subject of pesky children in Hague Convention cases and abduction cases, there was a case of Re AB, which is a rather unusual case of a rescission of an order. So this case involved the removal of 2 children from England to Spain by the father. One child was 17 and a half years old and one was 12 and a half years old. And the mother issued proceedings in the Central Family Court in London, and she obtained an order in front of a judge sitting as a High Court judge at a very short directions hearing. And this judge, who was clearly furious with the father's behaviour, ordered the children's return to England. Now, this judge did so without a CAFCAS officer or a social worker hearing the voices of children, did so at a directions hearing, and there were loads of questions about whether that was acceptable or not. The father then sought permission to appeal that decision, which I must say, rather surprisingly, was unsuccessful. He wasn't granted permission to appeal, and the order for the children's return from Spain to England was upheld by the Court of Appeal. The other complex factor is that this child was 17 and a half years old, and at the time was still 17, and yet a judge was making orders under the Children Act, under our domestic children legislation, over a 17 and a half year old, notwithstanding they should only really do that in exceptional circumstances, but there we go. So both children instructed a solicitor directly, had this return order to whom they were subject to, and applied to have this order rescinded or set aside on the basis of a change in circumstances under Section 31F of the MFPA 1984, which is quite an underused piece of legislation that came about recently. So the judge in this case was quite heavily focused on the fact that the 17 and a half year old said point blank, I am not going to go back to England. And the child's voice was so strong that she just refused to go back to England. And if a return order was enforced against them, the likelihood is the 17 and a half year old would stay in Spain, and the 12 and a half year old may cause a fuss but may have to go back to England. So the reason I talk about this is because I was the solicitor for the child in this case, and the judge talked in his judgment about this point of separation. And I'm reading from the judgment here, says, she later described her and her brother as inseparable. And she said, more than anything, I do not want to be separated from my brother. I'm not letting him go. She said this last sentence particularly firmly, with a slight quiver in her voice. So after that, the return order was rescinded. And for good measure, the proceedings were transferred from England to Spain because we had just got in previous to Brexit coming into force, the Brexit date coming into force and the end of the transition period. So I do feel for this mother who thought that she had sort of won the battle when she obtained this return order, and she probably would have gotten away with it too if it wasn't for these meddling kids. Probably a Scooby-Doo reference there, but it does really highlight the importance of children's voices being heard through a solicitor in this case, but able to rescind an order subsequently. So that's something to bear in mind whether you're for an applicant or a respondent. If you're for an applicant with these children, you want to get them on a plane ASAP. There had been quite a significant delay in that case. If you're for a respondent, well, it ain't over till it's over, quite frankly. Anyway, moving on away from Hague Convention applications, COVID continues to rear its ugly head in the UK, and this is still having an effect on family law. There's all these points about how proceedings can be served, how we've changed our ways of working, all these points which very specific. I won't go into too much detail. There's loads of allowances now made for the service of harassment orders, because there's all this idea that you're supposed to personally serve someone, but if they're isolating, can you personally serve someone? There's quite interesting points in that respect. Now, there's two other interesting cases recently, and another case of Mr. Justice MacDonald, where children who are in social services care are seeking to be vaccinated, because we have just started vaccinating children more and more. As time has gone on, the minimum age for vaccination has become younger and younger. And where social services share parental responsibility for a child, there can be a dispute about if and when a child should be vaccinated. So on these two cases, the children themselves were older, they wanted the vaccine, and the local authority wanted to get them the vaccine, but one or both parents was anti-vax, to use a colloquialism. The two judgments are very stark in this case. Quoting from the first judgment, Mr. Justice MacDonald says, "It is very difficult to foresee a situation in which a vaccination against COVID-19 approved for use in children would not be endorsed by this court as being in the court's best interest, absent evidence to the contrary." The judge very curiously says he deprecates the use of tendentious, partial, and partisan material gathered from the internet in what a previous judge accurately characterized as junk science, and placed before this court to support a personal belief regarding the probity and or efficacy of vaccinations. So in short, listen to doctors and don't get your medical information from Facebook, I think is what the judge was trying to get there. Again, these are arguments that are not necessarily new to COVID, but they've just been thrown into the spotlight with the COVID vaccine. And then from a divorce perspective, there's this quick case of HW and WW, which is a decision of His Honour Judge Kloss, where there are some comments about whether the COVID and the pandemic is sufficient to unpick a financial agreement made in divorce. We would refer to it as a barter event, and there's quite interesting discourse within that judgment about whether COVID can be a barter event, subject to some judicial consternation across the board. But here, in this case, a final order was entered into by the parties, one of whom was an influential businessman who had business links to China. However, what torpedoed the father in that case is that, or the husband in that case, is that he signed off a final financial order on the 12th of March 2020. And a couple of days later, the UK entered into our first of successive national lockdowns. So it can't have been unforeseen or unforeseeable, which is what the test that the previous case law was responding to. But it's quite an interesting judgment because it's something we certainly wouldn't have seen in times gone by. On a completely different issue and away from the lovely world of COVID is this fantastic case of the bank of mum and dad. And this is a case of FS and RS and JS. Now, this is a charming gentleman who was 41 years old, and he sought maintenance from his parents. He sought to rely on divorce legislation, failure to provide reasonable maintenance, Schedule 1 of the Children Act 1989 for financial claims for children, and under the inherent jurisdiction. So he was being rather creative indeed, and points to him for that. He was seeking to rely in part on the inherent jurisdiction, saying that he was a vulnerable adult, for quite complicated reasons, and the court was left to determine this application. And this came before our former president of the Family Division, Mum BP, and he starts the judgment by saying, "This is a most unusual case. Indeed, so far as I'm aware, and the very experienced counsel who appear before me do not dispute this. The case is unprecedented. Certainly, the researchers of counsel have identified no decision directly on this point. I suspect the initial reaction of most experienced family lawyers would be a robust disbelief that there is even arguable substance to any of it." So perhaps not unsurprisingly, he concluded that the High Court had no jurisdiction to order this adult son maintenance under only the 3 limbs that he sought. He later sought to make an application on the basis that his human rights were breached. Creative, as I say. And this matter then went to the Court of Appeal, who refused his application for permission to appeal. And he rejected the appellant's argument as well that he was subject to discrimination in this case. I will say the judge does refer to him as an unusually difficult, demanding, and pertinacious litigator. And when he went to the Court of Appeal, his name was placed into the public domain. And if you search for his name, it turns out that this same gentleman also sued the University of Oxford, from which he gained a degree in, I think it was history. He alleged that the teaching on his degree was weak. Because of that, he only received a 2-1, which is sort of the second rung of our university degrees. And he sued them because he said that because of his 2-1 degree from Oxford, he could not possibly pursue a high-flying career with, say, a US firm or become a barrister. And instead, he had to settle to be a lowly solicitor. I've tried researching the Oxford University case. It seems that that one was dismissed as well, much like the one against his parents, both with costs. But points for trying, I guess. And looks like the bank of mum and dad says no, is entitled to say no. And the statutory language is very clear in that regard. But I can imagine he's probably not going to go around for Christmas anymore. Next, diplomatic immunity and children's rights. Now, this is an absolutely fascinating and tragic case brought by the London Borough of Barnet. So this is Children's Social Services in one of the parts of London who had real concerns about children who were the sons and daughters of diplomats based in London. Now, because they were the sons of the parents were diplomats and they did enjoy diplomatic immunity, the rights afforded to them in the Vienna Convention on Diplomatic Relations applied. And I'm sure you all remember it from law school, but in case you don't, Article 31 says of the Vienna Convention says that a diplomatic agent shall enjoy immunity from its civil and administrative jurisdiction, except in very limited circumstances. A diplomatic agent is not obliged to give evidence, and no measure of execution may be taken in respect of a diplomatic agent. Now, this came before Mr. Justice Mostyn initially, who could not, in his mind, make an emergency protection order, which is an emergency order placing these children into foster care as a result of this issue of diplomatic immunity. He made no order on the local authorities' application, but he did later find that the experiences that the children had suffered at their parents' hands was tantamount to a breach of their rights under Article 3 of the European Court of Human Rights, which is a prohibition on torture, inhuman and degrading treatment or punishment. That notwithstanding, the London Borough's, the local authorities' application failed due to this issue of diplomatic immunity. They sought a declaration that this was incompatible with the human rights of the children. It's a very interesting, borderline academic case, but still, this went to the Court of Appeal, and two judges, including our president of the Family Division, said that the domestic children legislation, which allows for emergency protection orders, is subject to the Diplomatic Protection Act 1964, which incorporates the Vienna Convention into our domestic law. The judge said that immunity may be waived or cease, and it is not reasonable, possible, or proportionate to require a state to breach the Vienna Convention due to the importance which it has in reciprocal and global international relations. This case got hideously complicated. It ended up involving the Secretary of State, who asked for the sending state that the family were to leave. He declared them to be persona non grata. They were required to leave. Two of the children stayed behind and claimed asylum. Again, that asylum thing cropping up everywhere we look. Two children also claimed asylum thereafter, and then the parents with the two youngest children went back to their country of origin. And this application for Declaration of Human Rights came in thereafter. Very, very interesting case there. And it does actually go into detail about how many cases in which this is happening. This is not the first case in which this issue is coming before this court. And it's quite interesting to see the court balancing the rights of children versus diplomatic immunity. Now, this case of Al Maktoum and Princess Haya, you may have seen it being reported all over the shop. So this is a series of judgments from the High Court and our President of the Family Division, in which the gentleman in the picture, who is the absolute ruler of Dubai and the Prime Minister of the United Arab Emirates, was involved in this case against Princess Haya, who is, I believe, the daughter of the royal family of Jordan. This case reads like something out of a Hollywood blockbuster. It is insane, for want of a better word. The mother made a series of staggering allegations to the court, including that she had been kidnapped, or the father had orchestrated the unlawful abduction of his adult daughter from the UK to Dubai. There's allegations of them being drugged. There's allegations of them being forcefully returned to their home in Dubai, including by an armed commando assault at sea near the coast of India. And both women were thereafter deprived of their liberty. It goes on and on. The case itself is actually quite interesting because in this load of proceedings, where the mother in this case is making a huge amount of allegations, the father instructed his lawyers to withdraw from the courtroom, and it was just whether these allegations were found or not. So it talks about the burden of proof, notwithstanding the fact that the father doesn't engage, and the court does go on to quite vigorously, I've got to say, investigate these allegations and makes a determination pretty much across the board in the terms there. The case is even further complicated on the basis that, as head of a foreign state, he alleged that he could not take part in proceedings in the English jurisdiction, and that his absence did not mean that the court, however, could simply accept everything that the mother said. This didn't end there. He was later found to have ordered the hacking of his ex-wife's phone and her lawyer's phones, and mounted in the words of the judge, a sustained campaign of intimidation and threat. He sought to buy a mansion next door to the mother in England. He posted poems that he was apparently composing himself online, to the point where the mother found that they were intimidating, or she felt they were intimidating. And it goes on and on and on. So the judgment includes issues of diplomatic immunity, state actors, kidnapping, publication issues about whether they should be put in the public domain, maritime law, enforcement overseas, kidnap, findings of fact. Cherie Blair, the wife of the former Prime Minister Tony Blair, makes an appearance at one point. It is insane. They're all available online, these judgments. It makes for great bedtime reading. And then finally, the largest ever divorce settlement was between this couple, and it's a judgment of Mr. Justice Moore that came out relatively recently. So he ordered that £554 million was to be given from the Sheikh to Princess Haya. I don't know what the current rate is, probably best part of $1 billion US. The case goes on and on and on. The settlement makes lump sum payment of more than £250 million to the princess, as well as provisions for personal security, armoured vehicles for the family, education, a nurse, nanny, other staff, ponies, pets, farriers, drivers, you name it, it's in the judgment. And there's a long schedule attached to the judgment. And the judge does conclude his judgment by saying that Princess Haya has been placed in a position of great fear. The Sheikh had deliberately used his connections with the press to generate hostile stories aimed at destabilizing her and harming her. He published poems he considered by her to be threatening, including one entitled "You Lived, You Died." The president concluded that the Sheikh would use his very substantial powers to achieve his aims. If you're up for a bit of bedtime reading, which goes into the realms of Hollywood, then I'd thoroughly recommend it. And then finally, ISIS and children law. Now, this is a series of cases that have come out from our courts, both the divisional court, the administrative court, and our family courts. And the first one is a lady called Shamima Begum, who will be a household name to all the Brits amongst us, who's become somewhat of a cause célèbre in the UK. She was quite young herself. I think she was 15 when, following the involvement of others, she and two friends travelled from the UK to fight in Syria and join ISIS. Not content with life in East London, I think she was in Tower Hamlets. She left to find a new life in ISIS-controlled Syria. In due course, the Home Secretary stripped her of her British citizenship, which is the approach that the British government has been doing over time, so long as these people are not left stateless. Shamima Begum is by no means the only person who's gone out. There are quite a few people who are coming before the courts later down the line in which this issue is pivotal. So initially, the Court of Appeal had decided that it was wrong for the Home Secretary to suspend her or to terminate her British citizenship in this way. This was overturned by the Supreme Court, which allowed it and sided with the Home Secretary, and the Supreme Court dismissed Shamima Begum's challenges regarding the loss of her citizenship and stayed everything until such time as she was in a position to play an effective part in it in the proceedings without the safety of the public being compromised. This is something that also featured in the case of the Queen on the application of Abdullah Mohammed Rafiqul Islam versus the Secretary of State of the Home Department. Now, this was a case in which a gentleman left the UK to travel to Syria to join ISIS as a fighter, and this was an application brought by his father, who was seeking for him to be returned, and he sought the assistance of the British authorities to repatriate this gentleman from Syria to the UK. So the father heard from his son in May 2018 when a message was conveyed to him through the Office of the International Red Cross, who was based in Syria, and that this gentleman had been detained in a military prison in Kurdish-controlled northern Syria. The message read, and this is quoting from the judgment, "Please do whatever you can and contact whoever you can to help. It's been 4 months for me here and no one knows what's happening." The father lodged an appeal against the stripping of this gentleman's citizenship and an application for judicial review after his appeal was dismissed. And the divisional court said that held as follows, which perhaps speaks for itself. Any British citizen who commits serious crimes abroad is subject to local justice and cannot simply demand that the British government extricates him from a situation of his own making, so that he may face a more palatable prospect of justice in a British court. Pretty obvious. Anyone would think that. And you're probably wondering why I'm raising these two cases in children law in a discussion about international family law. Well, this is something that is not unique to the British system, and is something that our friends in France are also having to deal with. Now, for those of you who aren't aware, perhaps in the US there were quite a few fighters, in inverted commas, who left several states of the EU and the UK, travelled over to Syria via Turkey, via Lebanon, and started fighting for ISIS in some capacity, and thereafter have had children whilst out there. And I've certainly got one of these cases at the moment. They are creeping their way through the courts, where you either have British children out in these refugee camps or they have been brought back. The question that is at issue in the case of HF and MF in France and JD and AD in France are applications by French parents who seek for the French state's assistance for the repatriation of French children and their grandchildren from Syria. This is very, very interesting. And it's about the positive obligations of a state to protect these children and who have their citizenship and bring them back from an active war zone in Syria, ISIS-controlled Syria, or around there, or who are currently in one of the many refugee camps. This is something that has caught the European Court of Human Rights' attention and was referred to the Grand Chamber. It's a big deal. The court is analysing this and heard full argument about it, I think, on the 29th of September last year. The case will be determining whether this policy should be upheld. Are the children's rights separate from the parents' rights in this case, and should the children be separated from their parents? The judgment of this court has not been handed down yet. I think it will be quite a headline-grabbing one in due course. The policy issues in this case are huge. Do you separate a child who bears no blame from a parent who has run off to Syria? Do you leave them both there? Do you bring them both back? Do you take away a child who has grown up in a war zone away from their mother? Usually it's the mother. And their only primary attachment figure is their mother, and do you sever that in order for the child to come back to the UK or to France? We shall see. Watch this space, as I see. And I've got to say, a lot of these mothers, there is a question about whether they were groomed, whether they were obliged, whether they were hoodwinked, whether they were forced to go over to these states. Some of them were very young in themselves when they travelled over to Syria. So we shall see what the European Court of Human Rights has to do on that issue. I think it will be certainly one that the English system will be keeping a very, very keen eye on, because there were quite a few parents who travelled out to Syria, either with their children at the time or had children over there who are now British citizens. And whilst, for example, Mr. Islam and Shamina Begum, they lost their British citizenship, the Home Secretary in those cases relied on the fact that they probably had Bangladeshi citizenship and therefore they won't be rendered stateless. The question then becomes, what about these children who are born in these war-torn areas who, for all intents and purposes, are probably British citizens, and what obligations does the state have in order to protect them? So we shall see. So maybe this time next year, hopefully, if you invite me back, I will be discussing this case with you. But in the meantime, I think that is it. So thank you very much for listening, and over to you guys.
Thank you. I really appreciate everyone being here. And for those of you who registered, you will be getting an email from the American Bar Association that will include a recording, because this was recorded, and it will include our slides. So you'll have all the case names, so you can certainly do that bedtime reading that James is urging you to do. Thanks so much for being here, and Happy New Year to everyone.
Thank you.